Good evening to the aspirants of the 17th cohort 2022 All India Bar examination. Welcome, Karibu Sana, to my online class. And what I posted on the screen, can anyone unmute and read? What I posted on the screen, can you unmute and read?
Sir, gavel and sound box.
What is that?
Gavel and sound box.
Tort-Law is written here.
Oh,
Okay, that is gavel and sound block, it's okay, but Tort-Law also written over there. I am getting the car sound, the horn sound. Please mute it. When you want to speak at the time, you open it. Because I will get the extra sound. Yes, this is All India Bar Examination, 17th Code 2022, Law of Tort, multiple choice questions. Ready, be ready for the first question. The first question goes in this manner. Dash, and it is one of the necessities of law of torts. Number one, where there is a wrong, there is a remedy, virgule, redress. That is number one. Number two, where there is a illegal, there is a redress, virgule, remedy. Number three, where there is a false, there is a redress, virgule, remedy. Fourth, where there is a wrong, there is a redress, virgule, remedy. Which one is attached to it? Which one is the suitable one?
sir, first one, sir, where there is a wrong, there is a remedy.
What about the last one?
Public redress, sir.
Where there is a wrong, there is a redress and remedy. Which one is the right answer?
First one, sir.
Yes, the first one is the right answer. Redress and remedy is the right answer. Not the first one. The last one is the right answer. The first comes redress, last comes remedy. I repeat, the first comes redress, last comes remedy. Where there is a wrong, there is a redress or remedy. That is the right word. Is it clear? Say yes.
Yes, sir.
Good. Second one, unmute and read. Anyone can unmute and read second one?
Second question, which is correct statement among four? First option, no damage must be permitted to go punished. Second option, damage must be permitted to go unpunished. Third option, no damage must be permitted to go unpunished. Fourth option, no damages must be permitted to go unpunished.
Which option is correct among the four? Number one, number two, number three, or number four?
Number two, sir.
Damage must be permitted to go unpunished. You are giving the permission. The right answer is number three, no damage must be permitted to go unpunished. I repeat, which is the correct statement among four means number one wrong, number two wrong, number four wrong. Number three, no damage must be permitted to go unpunished. That is the right answer. Is it clear? Say yes.
Yes.
Good. Third question. Match the following. Latin maxim part A, which I have given here. Then it's case law, which is used in the decided cases. Number one, demnum sine injuria. Number two, injuria sine demnum. Number three, ubi jus ibi remedium. Number four, exturpi causa non aritor actio. And here the part B. A. Hallman versus Johnson. B. Bhim Singh versus State of Jammu and Kashmir. C. Ajbi versus White. And D. In case of the Gloucester Grammar School. Now, the match the following is number 1, ID 2C 3B 4A. Number 2, ID 2C 3A 4B. Number 3, 1, that I means 1, 1C 2D 3B 4A. Fourth, 1D 2C 3B 4A. Which one is the appropriate among the 1, 2, 3, 4 Arabic numerals? Yes. Which is appropriate? Shoot, even though it is wrong, doesn't matter. Demnum sana injuria, damage without legal injury.
Option 2, sir.
1D, 2C, 3A, 4B. See, you will compare it here now. Demnum sana injuria, in the case of Gloucester Grammar School. Gloucester Grammar School is D here. So 1D, okay, that is right. Next, injuria sana demnum, Ashby versus White. Here 2 means C, 2C. 1D, 2C, right. And next, UB just EB remedium. This is Bhim Singh case. Bhim Singh case is B. Then 3B. Yes, that is right. Here, 2 is not 3B, 3A is written here. So that second option is wrong. So 1D, 2C, 3B is very good. No problem at all. Now the fourth one we will see. Exturpi causa non ariter actio. For that case law is Hallman versus Johnson. And here Hallman versus Johnson is A. So right answer is 1D, 2C, 3B, 4A. Is it clear?
Yes, sir. Yes, sir.
Fourth and
See,
both
one
are
also
same,
correct,
sir.
1 also correct, 4 also correct. See, 1D, 2C, 3B, 4A. Even 1 also correct, even 4 also. Say,
Fourth are
Yes,
correct.
sir. 1 and 4 same.
1 and 4 same, hence both are correct. Is it clear?
Yes, sir. Yes, sir.
Yes, that is the way we have to make it out. Fourth question. The plaintiff was aware of that the defendants act to smuggle the tea to England without reimbursing the legal obligation, and he sold and delivered the tea to him knowing all of the facts if decided case law. What is the decided case law? Where these facts were made and the plaintiff served the tea, delivered the tea. Number 1, Hallman versus Johnson. Number 2, Holmes versus Panther. Number 3, Davy versus Christie. Number 4, Shreyas Singhal versus Union of India. Never Shreyas Singhal versus Union of India. It is entirely different. So we can eliminate it. Yes. Which one is the right answer? And Davy versus Christie is the music teacher. He is giving the music lesson. And if you have the BBC body-to-body contact, your tone will be the increased. Good way. It is a consent obtained by the fraud. It is not. So among the Hallman versus Johnson, Holmes versus Mather, the first one is the right answer. Hallman versus Johnson, where these facts of the case lies decided. So the fourth question, right answer is? Yes, fourth question, right answer is?
Option 1.
Fourth question, right answer is? Fourth question, right answer is? 4 times I said, but you are not giving the reply to my question. Which is the right answer?
Option 1, sir.
I told you already, because Davy versus Christie, not at all. Then the Shreya Singhal versus Union of India, not at all. Then the first is the option. There is a Hallman versus Johnson. Holmes versus Mathar is a different case law. So fourth question, right answer is?
First one, sir. First one.
First option, Hallman versus Johnson. That is the reply you are supposed to say. Okay, which one is correct one? Because it's a very bigger one. I read. You cannot read. You may not read also in the speedway. Number 1, the court stated that the action for the lawful harm sustained by a person suffers will die with him, but that the above maxim does not apply in the case of damages or loss to person's property. Number 2, the court stated that an action for the lawful harm sustained by a person suffers will die with him, but that the above maxim does apply in the case of the damage or loss to a person's property. Number 3, the court stated that an action for the lawful harm sustained by a person suffers will die with him, but that the above maxim does not apply in the case of the damage to loss or person to property. Actio personalis is maritam cum persona. It's the example for this one. The personal action dies with the person. So which option is correct option among the 4? All of them are number 1, or number 2, or number 3? Shoot, even though it is wrong, there is no minus marks.
Sir, option 2.
Wrong.
Sir, option 2.
Repeat.
Option 2, sir.
Repeat. Your last word I could hear, but the first word I could not hear. That's why I say repeat.
Sir, option 2, sir.
Option 2, wrong. Just before I told you. Option 3 is the right answer. I repeat. Option 3 is the right answer. You check it. Action for a lawful harm sustained and action for, see here an action should come. See here an action, there is an is removed there. So in any way it is wrong. Second one is lawful harm sustained by a person suffers will die with him, but that the above maxim does not apply in the case of damages or loss. Something I changed it here. The court stated that an action for a lawful harm sustained by a person suffers will die with him, but that the above maxim does not apply. Here not I removed. So second option will not work because here not is there, here not is not there. So the second option will not work. Only this option will work. Hence, the right answer for the 5th question is the third option. The court stated that an action for a lawful harm sustained by a person suffer will die with him, but that the above maxim does not apply in the case of the damages or loss to the person's property. That means actio personalis is maritam cap persona is not applicable to the person, but property it will be applicable. Okay, next. The 6th question. Q facit parielam facit per se. It means, number 1, whenever a person has something done for them by someone else, they are considered to be the following, performing the act themselves. Number 2, wherever a person has something done for them by someone else, they are considered to be performing the act themselves. Number 3, whenever a person has something done for them by someone else, they are not considered to be performing the act themselves. Number 4, whenever a person has something done for them by someone else, they are considered to be performing the act themselves. Which one is the appropriate one? Which one is the appropriate one?
Option 4, sir.
Facit per se. Yes. Say. 2 participants are
Option
waiting in
4,
the
sir.
line. Yes. Which one is the answer? Repeat. I did not hear your voice.
Option 4, sir.
Option 4 is you want to say. No. A person have. Person means third person singular. There should not be have, has. So number 1 is the right option. Whenever a person has something done for them by someone else, they are considered to be performing the act themselves. That is the exact answer. I intentionally put the have here, but there is it's showing also what is underline, two underlines are showing because it's not proper grammatically. So have should not be there because third person singular it should come has. So the correct answer is the sixth question is one. Whenever a person has something done for them by someone else, they are considered to be performing the act themselves. That is the answer. Qui facit periodum for say it means whenever the person has something done for themselves by someone else, they are considered to be performing the act themselves. Seventh question. In ready mixed concrete, that is RMC versus Minister for the Pension and the National Insurance 1968, established the three requirements for a service contract. Number one, servant tends to agree to provide his abilities and work to the masters in exchange for the money or some other consideration. Number two, he tends to agree to be accustomed to such an amount responsibility that the person becomes his master in the efficiency of the employment. And third, some other clause of the contract are coherent with this requirement, being the service contract difference between the servant and independent contractor. Then which one is the appropriate answer? Number one, number two, number three, or all of the above? I will drag it to the next page. I will send it to the next page. Now you can see all four. Question is, it is decided in this case law. Then what are the requirement for the service, for a service contract? It is the service contract elements. Now you look at closely and you tell me that which one is the appropriate. 1, 2, 3, 4. Shoot. There is no minus marks. Yes.
Option 2, sir.
Option 4. All of the above. All are the ingredients of a service contract. So option 4 is the right answer. Is it clear? All ingredients, number 1, 2, 3 is the service contract ingredients. And hence, all of the above is the right answer. Okay, now, anyone is a small one, anyone can read. Unmute and read. Anyone can unmute and read. 8th question.
Question number 8. Slander is to the dash and label is to option 1 eye and ear, option 2 ear and eye, option 3 tongue and eye, option 4 eye and tongue.
Do you know what is slander? Do you know what is libel? It comes under defamation.
Don't know, sir.
Libel is a written statement and slander is a oral statement. So slander even is oral. When you say oral, who will listen? Ear will listen. Then if you write the written form, who will read? Eyes will read. Then which one is the appropriate word here?
Second option, sir.
Second option. I don't know why it is a basic thing it is. Your defamation you read off chart because you are giving, now going to write the All India Bar examination. And when you defamation says slander to the ear and libel to the eyes, it is clearly written over there. By looking it, immediately you should have to give the answer for this question. Anyway, okay, doesn't matter. And this is also very easy question. Inando. What is inando? Actually, pronunciation is innuendo. Innuendo. That is the right pronunciation. Yes, what is innuendo? Is it a defamation? Number 1. Number 2, not defamation. Number 3, partial defamation. Number 4, both are liable. Means person who did and person to whom it is made, both are liable. Means plaintiff and defendant is liable. Yes, Inundo. In Telugu, if I say, I don't know how far that you will understand. Raju Gari Modati Bharya Pativrata. But it means, if you see the statement, a plain statement, it is a common statement.
Partial, sir. Partial deformation. 3.
If you read in the between the lines, it is a defamation. Raju Gari Modati Bharya Pativrata. King's first wife is a monogamist or chastised woman. Does it mean the second and third are unchaste women? It gives the same sense. So innuendo means it looks to be plain statement, but if you read between the lines, it is a defamation. So answer is ninth answer is here. Ninth answer is which option?
First
3,
one,
sir.
sir.
When I gave clearly the explanation, I am asking
Three.
you, and you are taking so much time. It's a demonstrative defamation. I don't know. I did not ask the FEG. Do you know EFFIGY? I repeat. EFFIGY. FEG, you know. Do you know what is meant by FEG? EFFIGY. I magnify it. I enlarge it. Do you know what it means? Yes. Did you see it? Say yes. Do you know its meaning?
Yes, sir.
No, sir.
No.
Do you know its meaning?
Don't know, sir.
No, sir.
Say pass on. If you don't know, say pass
Pass
on. I
on.
will give the answer. Why do you waste my time?
Dishtabamma, sir.
It is not exactly distibama, but looks like a distibama. A dummy, a dummy is made of a particular person to whom they want to show the protest, and they will burn the effigy in the four corners of the road to show their protest that he's misused the funds, either a minister is concerned, or the government employee is concerned, or public servant is concerned.
Reflection image, sir. Reflection image.
Yes. That is called FEG. ఆ దిష్టి బొమ్మని ఏమంటారంటే అది మన మన వంట చేనులలో ఉంటాయి చూడండి, ఫీల్డ్స్లలో ఉంటాయి, దాన్ని వేరే అంటారు. దాన్ని ఏమనాలా? ఏది ఫర్ క్రోస్ టు ఫియర్ and to birds to fear, or somebody in the night, if anybody see, then they feel that there is a man standing over there. Danni emanala? Danni effigy anaru danni. We don't call effigy for that one. Dishti bomma anedi vere untadi. Intlalo pedtaru dishti. Edi illu dishti padakunta. Danni anaru bhayapette danni scare crow antaru danni. Scare అంటే భయపెట్టేయడం. స్కేర్, SCAR, స్కేర్ హైఫన్ క్రో. క్రో అంటే తెలుసు కదా. వాట్ ఈస్ క్రో? CROW, కాకి. దాన్ని ఇఫీగి బర్నింగ్ ఆల్సో ఇట్ ఈస్ అమౌంట్ టు ఏ డిఫమేషన్, దట్ టు బి ఏ లిబల్. ఇంకా అవన్నీ అడగలే మీకు, ఎందుకంటే 10 అడగాలనే ఉద్దేశంతో ఐ డిడ్ నాట్ ఆస్క్ అదర్ థింగ్స్. ఓకే, లెట్ us come to the point next. The 10th question. How many types of nuisance are there in the law of tort? Which one is the odd man out? Read the option.
Option 1, private and public nuisance. Option 2, alluring nuisance. Option 3, anticipatory nuisance. Option 4, forthcoming nuisance.
Other 3 are acceptable. It is there in the nuisance chapter. One is not there in the nuisance.
Fourth one, forthcoming option. Nuisance.
There is no forthcoming nuisance. We can say anticipatory nuisance or future nuisance. There is a private nuisance is there, public nuisance is there, mixed nuisance is there, alluring nuisance is there. Alluring means luring. Actually, alluring, no, luring nuisance, we should say. or we can use the another word also for that luring nuisance. We can use another word also. Luring ante entante, suppose a trench is there. Trench is not luring to the children. Trench ante ఏమన్నానండి ఇది బొందనా? Yes, it's like a bonda in Telugu. Trench is not a luring to the one, but in the earlier days there are steam engines are there. Steam engines. If they want to turn the steam engine front to back to front, there is a yard in the railway yard. There is a turntable is there. I don't know whether you know the turntable. Do you know the turntable? Say yes or no. Do you know the turntable? Railways, imagine turntable is there. That is a nuisance. That is a alluring nuisance. See, this is the turntable. They will turn it. Here I am showing you. This is the turntable where the train will come and stand there, and they will move it. This side become this side. This turntable is a luring one. It is attracts the students as a they can play on it. So it is a luring nuisance it is created over there. Number one, we can say like that. And we also can say this is attractive nuisance because it attracts the children. We can also say attractive nuisance. Yes, either we can say luring nuisance, or we can say more preferably is attractive nuisance because it attracts the student because they want to turn it. It attracts. So we can write here 2. Instead of writing luring, you can write attractive nuisance. Yeah, this is the ATTRATIVE. Attractive nuisance, anticipatory nuisance, or the forthcoming nuisance. And there is no forthcoming nuisance is there. Okay, now let's come to the what is IDP in the Motor Vehicle Act or in the license. The full form is Indian Driving Permit. Number 2, International Driving Permit. Number 3, Indian Driver Permit. Number 4, International Driver Permit.
Option 4, sir.
మీ ఇంటికాడ మాటలన్నీ వినబడుతున్నాయి మేడం. You mute it when you are speaking in your phone. Yes, please tell me. IDP full form.
Option 4, sir.
Wrong.
Sir, option 1, 2.
Wrong.
Option 2, sir.
Right. International Driving Permit, that is a full form of IDP. IDP is which type of the abbreviation it is? I told you already 4 types of the abbreviation. IDP comes in which type of abbreviation? I explained you the 4
Acronym, sir.
type of abbreviations.
Acronym.
Number 1, initialism. Number 2, acronym. Number 3, shortening. Number 4, contraction. Among 4, IDP comes under which category of the abbreviation?
Acronym, sir.
Shortening, sir.
Initialism. Because you are pronouncing each word, each letter, IDP. So when you pronouncing the each letter, you can say initialism. But when you say completing the all initial in one letter, one word, like NATO, SATO, Cafeposa, Conservation of Foreign Energy, that is ICRISAT. It is there in Hyderabad, ICRISAT. ICRISAT is an acronym. It is not an initialization because we are pronouncing as a one word. Okay, 12th question. If anyone has obtained the IDP from his own country and his country is a signatory to the 1949 which convention? Number 1, Geneva Convention. Number 2, the Hague Convention. Number 4, Brussels Convention. Number 3, Berne Convention.
Option 1, Geneva Convention, sir.
It is a Geneva Convention where the licensure would be agreed because Berne Convention is regarding the copyright, and the Hague Convention comes especially for the jurisdiction. and a Brussels Convention recognition of the foreign judgment. So now let us see the 13th question. A person who obtained the IPD, he can drive in India the specified category of the vehicle till the IDP is valid. The validity of IDP is dash year from the date of issue or the validity. 1 year, 2 year, 4 year, 5 year. IDP validity.
4 years, sir.
Wrong.
5 years, 5 years.
Wrong. Only 1 year. When you take in the IDP, it is valid for 1 year. Of course, with that IDP, you can drive anywhere, but the country should be one of the members for the Geneva Convention. Yes. With that IDP, you can drive anywhere, provided it should be a Geneva Convention member. Only 1 year validity would be there. And the IDP will not be issued unless until you have the valid visa in India. And that to be at least it's more than 6 months validity would be there. Because it is 1 year validity would be there. Yes, it can be given. But 6 months validity, 1 year will not be given over there. Is it clear? Say yes.
Yes,
Say
sir.
yes.
Yes, sir.
Good. 14th question. Read. Anyone can unmute and read. Quick.
The 14th question, the Motor Vehicle Act, passed in the year 1988 by the Indian Parliament, regulates almost all aspects of road transport vehicles. It has provisions for dash, which is odd man out. It means not belong to the statement.
Number one.
First option, traffic regulations. Second option, vehicle insurance. Third option, registration of motor vehicles. Fourth option, controlling permits and penalties. Sir, first option, traffic regulations.
Why traffic regulation? Tell me. Does it not say the Traffic Regulation Motor Vehicle Act?
Sir, remaining three belongs to the motor vehicles. Vehicle insurance, registration of motor vehicle, controlling permits and penalties. Traffic regulation.
I think there is a controlling. I think all are correct. Not odd man out here. Because traffic regulations, yes, motor vehicle act covers. Vehicle insurance, yes, it is covers. Registration of motor, that is the actual the thing. Controlling permits and penalties. Yes, they will make the, yeah, all of the correct, not odd man out here. Better we can change it, that sentence. All are correct. Which one is correct actually? Not odd man out. So now let us see the 15th question. What are the features of the Motor Vehicle Act 1988? Let us see. One is not among them, I say. So number one, licensing of drivers and conductors. Number two, registration of the motor vehicle. Number three, control of the motor vehicle through license. Number four, traffic regulation, insurance, liability, offences and penalties. One is not among the four in the Motor Vehicle Act features. Which one is one? 1, 2, 3 or 4? Sir, this is a tough one, sir, unless until you know.
Option 1, sir.
Wrong. Option 3. See, you look at it. You look at very closely. Option 3. What is written there? Controlling of motor vehicle through license, I wrote. Actually, it is not a license. Through permits. I removed the permits there. I wrote the license. So, it is a bit tough for you to understand. There will permits will be given. Of course, driving license will be issued. Is it clear?
Yes, sir. Clear, sir.
Okay, now tell me. Sir, we know it, sir. The Motor Vehicle Act came into force from 1st July 1981, 2nd July 1981, 1st July 1988, 2nd July 1988. Which one is the correct answer? Which one is the correct answer?
Option 3, sir.
Yes. No. I think it is 89. 1st July 1989. That is the right answer. Not 88. 1st July 1989 is the right answer. Okay, now 17th question. Who is the owner under the Motor Vehicle Act 1988? Interpreted the expression owner in dash of the Motor Vehicle Act 1988 to be the person under whose name the motor vehicle stands registered. Number 1, Section 1, Class 30. Section 2, Class 30. Third, Section 2, capital A, Class 30. 4, Section 2, Section 2, Class 30, subclass small Roman 1. Which one is the correct answer?
Option 3, sir.
No.
Two, sir.
For make you confusion, I made like that.
Option 2.
Right answer is Section 2, Class 30 is the right answer, where owner is defined. Okay, next 18th question. The Honorable Court further clarified that that instance where the transfer of vehicle is not registered with an authority dash will be the responsible. Who will be the responsible? Number 1, original owner. Number 2, the second owner. Number 3, no one is liable. Number 4, all of them liable. Who will be responsibility if it is
Original
not
owner.
transferred?
All of them, sir.
No.
Original owner.
It is the original
Original
owner. It is the original owner is responsible. It is the responsibility of the original owner to transfer the vehicle when he is selling to the second owner. If any incidents happen over there, it is not the second owner is not responsible. It is the original owner is responsible for that one. So the right answer is 18th question. Right answer is
Original owner.
18th question. Right answer is say option 1, original owner. Say, please speak so that I know that you are with me.
Option 1, original owner is right answer, sir.
Yes. So 19th question. The time limit of dash for filing the claim. In the original act passed in 1988, there was a similar provision is there. What is the time limit in the original act 1988 when it's passed? It is a 3 months. Is it a 6 months? Is it 10 months? It is a 1 year. Time limitation period. I am speaking 1988 Act, MV Act limitation period. When it is passed.
Second option, 6 months, sir.
Wrong.
3 months, sir.
I think not. I think it is a 6 months only. Not 3 months, because intentionally I put the 3 months. No, 3 months I believe. Yeah. 3 months you have to file a case, not 6 months. 3 months is the right answer. But now, what is the position now? But the said provision fixing time limit was deleted. As per the which amendment it is deleted. Therefore, a claim could have been filed at any time without any limitation now for the Motor Vehicle Act. Which amendment will say like that? Is it the amendment 1992? Second option, 1993 amendment. Third option, 1994 amendment. Fourth option, 1995 amendment. Which amendment says?
94 amendment, sir.
It is the 94 amendment says there is no time limit for that filing the case in the motor vehicle accident. But earlier, it is a 3 months. Yeah, it is a 3 months. Now, 21st question, Consumer Protection Act can be written as initialism or acronym. Consumer Protection Act can be written as which type of abbreviation? I am not giving the option here. If I give the option, you can easily make it out.
Initialism, sir.
What do you call the initialism? Pronounce.
CP Act.
You say initialism. Okay, I agreed. What are the letters there in initialism?
CP Act, sir.
No. It is not initialism. It is the acronym COPA. 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 It is not initialism. Because we uttered it in one word. Hence it is here. Hence it is here.
Acronym, sir.
Acronym.
Acronym. Not acronism. Acronym. ACRONYM acronym. Okay, now what is called as a Consumer Protection Act? And what is the long title? Consumer Protection Act long title. Which one is correct among the four? I have given the four long titles here. I said which one is correct among the four? Because it's a big title, no? So if you read it, Act to provide for the protection of the attitude of the consumer and for the said purpose to establish authority for timely and effective administration and settlement of the consumer disputes and for matters connected therewith or incidental thereto. The second option, an act to provide the protection of the interest of the consumer and for the said purpose establishes the authority for timely and effective administration and settlement of the consumer dispute and for the matters not connected therewith or incidental thereto. The third option, an act to provide for the protection of the interest of the consumer and for the said purpose to establish the authority for timely and effective administration and settlement of the consumer's conflicts and matters connected therewith or incidental thereto. The last one is an act to provide the protection of the interest of the consumer and for the said purpose to establish the authority for timely and effective administration and settlement of the consumer disputes and for the matters connected therewith or incidental thereto. So I gave the first, second, third, and fourth option. Among them, which one is the appropriate one?
I think option 4, sir.
You closely look at it. Option 1 is not the right answer. I will show you the Consumer Protection Act. Consumer Protection. Which Consumer Protection Act this is? 18th, old version and new version. Why it is showing only the Consumer Protection? I say Bare Act. So images showing Bare Act, not images. I think it is Bare Act I told, but it's showing the other things. Yeah, it is here. But it is not showing very clearly. My purpose of asking is, they can ask you the long title also. That's what I want to convey to you. They say short title and they will ask the long title full and they will give which one is correct, which is not correct, and they will ask in that way also. It is not showing this. It is showing some other thing. So that is my intention. And when it is came into force, this is another question, supplementary question. Which one? The new act. The new act, when it came into the force. Anyone? Because it is did not come in the force on in 2019. No. It is 22nd June or July 2022. 20, it came into force, the total act. So that would be the, let me check it because it is obstructing me. This one is obstructing me. There is Yahoo it is showing, but I want to see in the Google, but it doesn't matter. When Consumer Protection Act came into force in the year. No, it is the right option, it is not showing. The site can't be reached, say. We'll search in this Google search engine because the search engine is not proper one. Again it is came. Okay, search engine, I changed it. This is has come. So my point of saying is a question can be asked also when came into effort. And what is in the old act they say district forum, but in the new act what do you say? Anyone? In the old act we say district forum, but as per the new act, participants, are you there with me? You are not supposed to silent. Monica, I could not see your microphone. Participants, are you there? You have to say yes, otherwise I cannot move.
Yes, sir.
Then why you are not giving answer? Say pass on. If you don't know, say pass on.
Okay, sir.
What okay? Say pass on, I told you. You have to say pass on.
Pass on, sir.
That is the spirit. That is the actually. That shows the sense that, yes, you are with me, you did not sleep. Okay, okay. In the old act, they say district consumer forum. But as per the new act is concerned, they changed it. They say district redressal commission. The word they used it. And another difference which I want to show is the old act jurisdiction is increased in the new act. I repeat, the old act jurisdiction is changed in the new act because the jurisdiction is increased. They increased for the district commission, they increased for the national commission, they increased for the state commission. And there is a difference between their two acts. Sometimes they may ask you at least the differences would be there and how it would be. But I send the WhatsApp message to you, but nobody has given the reply to me. Whether the old act is they are using or giving there or the new act they are going to ask it, please make the clarification for that regard. But not a single person has taken the care to reply to me. At least, sir, we don't know. Because if I frame the question in the new act, suppose the new act cannot be asked over there, but it is you should have to know which act you read in your syllabus. Yes? Which act you read for the examination LLB? Sorry,
I think new syllabus, sir.
but why you did not give the reply to my question? Sir, I did not see it, sir. Because I see only, I don't see, but just I join it, that's all. Please, instruction, please read it. Whenever I want to give, and you have to read and you have to give the reply. See, I could not in a confusion, I could not make it a more multiple choice questions in the Consumer Protection Act today. I did it 10, okay, but if I do 10 also in this one, there will be a justification. When I don't teach properly, even my mind, my conscience will say, I have not dealt in proper way today. So I did not do a proper way today because I did not collect the Consumer Protection Act, either the old or new. So a confusion would be there, I did not collect it. Because if I teach you the new one, and it's well and good. If I teach the old one, sir, you say, sir, you taught the old one according to the sections are concerned, but the new one is asked over there. It is you have to know it, whether the old act is start or new act is start. You would have to make it clear in the morning session. Then I would have to make it certain questions were there. But still, I can give some hint to you. What are the changes should be there? And they have made the changes also where one can file a case. But generally, a person who purchased in Hyderabad, can he file a case in Khammam? As per the new act, answer is yes. As per the new act, answer is yes, because the plaintiff is a resident of Khammam, but he purchased the goods in Hyderabad. It does not mean that where the goods are purchased, there should be filed. It can be filed also the place where the plaintiff is having the permanent residence. Yes, you can file a case. Where? Khammam. If an accident happened in Hyderabad and the plaintiff visited Hyderabad for some purpose or for some work or for the training, if he got injured over there, you need not to file a case in Hyderabad. You can file a case where the plaintiff is having the permanent residence. Is it clear?
Yes, sir.
In the legal terminology, what do you say this? In the legal terminology, what do you say? Say passa.
Jurisdiction. Jurisdiction.
Jurisdiction, you say. So which court having the jurisdiction to entertain such a case or admit such a case? So jurisdiction also you can make, because same jurisdiction will come in the private international also. See, when the private international also, when the conflict come from one country to another country, and where he bought, that country law will not be applied. Of course, that country law will be applied because lex cause, a cause of action is there. But he is a resident and he is a citizen of India. And at the time, he got injured there in the, say, about the United States of America. He can file a case over there, no doubt. But he stays over there for the 2 months or 3 months or 1 month or 15 days. At that instance, he can file a case. Forum convenience is there in India also. When in India he filed a case, the theory of obligation will work out there, even though India and USA may either have a treaty or may not have a treaty, but they have to respect each one's obligations. And at that instance, the case will be entertained here, the judgment will be followed there in the USA. That is called recognition and enforcement of the foreign judgment. It comes under the private international law. Of course, you don't have the private international law in your syllabus. You have only public international law. But private international law is highly important at this scenario. Why it is a private international law is very important? Can anyone give me the answer? Why private international law is having the permanent role now? Because world is a small one, Hamlet. It is on the palm. People will migrate because of the globalization, liberalization. They can take the breakfast in India and the lunch in the Kenya and the dinner in the Uganda, because they do have the business in the various places, and hence a dispute will come over there. At that instance, definitely forum convenience will be the chance given to the plaintiff for the private international law. Hence, private international law should become a compulsory course in India. And that to be, if the third year courses are there, it is a third year, first semester it should be placed, or my view is better it should be placed in the second semester, because by that time you study all the laws, like civil procedure code you studied, criminal procedure code you studied, transfer of property you studied it, law of tort you studied it, contract you will study it, and you may also study the family law also, because it covers the entire matrimonial dispute, civil contracts and torts, transfer of property and inheritance or succession or trust. And you all will study when you come to the third year, second semester. In Tanzania, earlier it is only the optional course. Now it is a compulsory course in all universities. Because like UGC in India, in the Tanzania, TCU, Tanzania Commission for the Universities are there. They made the compulsory course private international law in all the university, including the public university. Participants, are you with me? Say yes.
Yes, sir.
Very good.
Yes, sir.
Good. But no one has given the reply to my question, which I posted on the WhatsApp. So you read in that way, new Consumer Protection Act, and which can be also known as COPA, C-O-P-A, COPA, which is an acronym. And when it is implemented, what are the differences would be there for the new act to the old act? Whether new act, whatever the lacuna would be there, that will be covered in the new act. In the new act, electronic transactions are incorporated over there. Online transactions. And jurisdiction is increased. And a plaintiff can file a case from his permanent residence, not the place where he purchased the goods. So these are the things would be there. You study it and make certain questions in it. So the next class, what is the next class tomorrow?
Sir, I have one doubt. Shall I ask?
Yeah, please ask.
Sir, if I purchased any electrical device from the US,
Okay.
then which act shall be applicable, sir? I think is COPA 2019 applicable, sir?
That's why a conflict will come. Don't buy anything on online, because law is not very much perfect in online. The reason is, we say that even though you purchased there, but you can file a case in India. If you purchase, the manufacturer is there in the USA. If any mechanical defect would be there, but that cannot be solved because of such a thing. If he is having the branch here, okay, you can file a case. So that is another issue. Branch is also an important factor. If he is having the branch, okay, you can file a case here. Otherwise, never purchase any goods online, because to avoid the complications, don't buy the tension. Is it clear? So
Sir,
next class is
Taxation.
Law related to taxation.
I already posted on the screen. I'm asking you. Anyway, better I got the reply, though it is late. So next class is law related to taxation. So please make it ready and give the answer, shoot it as soon as I finish the fourth option. I should not supposed to repeat it. Please shoot it, even though it is wrong, doesn't matter. At least the mechanism that you have developed in your brain, the software you developed in the brain, how far that it works, you can test it by shooting. Is it clear? Say yes.
yes, sir.
Okay, with this, that I would like to stop it today class, and we'll meet tomorrow, preferably the same timings of the 6:10. And here, when you say 6:10, and here 3:40, because 2.5 hours you are ahead, we are behind 2.5 hours. So when I say 6:10 to you, at the time I should be very much ready by 3:40, because today I took the 2 classes consecutive for the law and development, even though it is not my course, because I do have only 3 students in masters in one stream and 3 students in the master in another stream, which will not make me happy to teach in India, in Tanzania, coming from India. So I asked the Vice Chancellor and say, sir, you can go ahead in which area that you are comfortable, you can teach. But it is only a service. But I don't conduct the examination. You know how many students are there in one course? 900 for the law of tort and 1,000 in legal research, and roughly 250 to 300 in the fourth year. No, yeah, it is a 3rd year, because it doesn't have the 4-year course here, only 3 years course. And in the UDSM, it is a 4 years course, because when you 4 years course, you will say honors. and we have the many subjects over there. And extra subjects are there. That's why we say law from the UDSM is a fort of law. If a person who studied law in the East Africa, you are supposed to come and study law in the UDSM at that time. But now, because at the time it is a East Africa in University of East Africa. But now they become independent. So Kenya made the Nairobi University and Makerere University in Uganda. So they divided, and hence they do have their own specialization now. Otherwise, the specialization, if anybody wants to study law, he should have to come to the Dar es Salaam and study it. Because in other places, law is not there. Only faculty, other faculties are there. But here only the UDSM, there is a fort, and hence it is very labeled as, it also can be said as a Harvard of East Africa. University of Dar es Salaam is said as Harvard of East Africa. Okay, with these words that I would like to stop my today class. Jai Hind.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड़ उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्छल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मागे गाहे तव जय गाथा जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
सारे जहां से अच्छा हिंदुस्तां हमारा। जय हिंद।